One of the best bits of advice I could ever give you if you're going to go to court to make an application, or if you're going to be an advocate in a moot, is that you use the word submission correctly. Why does this matter? Well, let's take a run up to that question. The courts have progressively come to love questions and answers. In any application, there will be questions. For a start, you'll need to think about what questions arise in the case as a whole, and we call those questions the issues in the case. In a moot, you are given them. Otherwise, the lawyers have to figure them out. In an interim application, you have other questions. They're posed by the law that governs that kind of application. So, for example, if you're appearing in a summary judgment application, you'll need to think about the question as to whether or not the defendant has a realistic prospect of successfully defending the case. So if the law requires the lawyers to figure out the questions, you must bring the correct questions to the court. It also follows that you must bring the court the answers. And those are your submissions. It follows then that a submission is analytical. They're about how you say the evidence and the law fit together to answer the questions that the court has to answer. Typically then, you'll make submissions to say things like the law should be understood in a particular way. That's common in mooting. Or that the court should rely on a fact, saying that that fact has been proven or is likely to be so. Or that the law should be applied to the facts in a particular way and with a particular outcome. Why are submissions so important? Well, when a judge hears the word submission, the court will assume that this is the finding, judgment, or ruling that you want the court to give. So if you make 3 submissions, effectively you're asking the court to make 3 findings. So here's a great tip. Try interchanging the classic formulation, Your Honour, I make 3 submissions in this application, with I invite the court to make 3 findings in this case. If you can readily interchange those formulations, then you are using the word correctly, and it means that the court knows exactly what you think its judgment should be. And that's what the court wants from you.